Hello, everyone, and welcome to another exciting edition of the ESQ Practical Lawyers Academy free webinar series. We are glad you could join us today. My name is Chidima Agum, and I'm a Research and Development Legal Associate at ESQ Trainings Limited. We are very honored to have three learned silks with us today. Thank you so much for joining us. At ESQ Trainings Limited, our mission is to expand the frontiers of continuous professional learning with courses and training across various areas of practice. We have tagged this webinar series, the Launch Hour webinar series, as they are slated to hold at 1 p.m. during lunch break. They'll hold three times every week, Mondays, Wednesdays, and Fridays. However, in order to accommodate our Muslim participants, the Friday webinars will hold at 11 a.m. And after every session, we'll provide the resources in easily accessible format for those who are interested. So before I go on, you can now watch our webinars on our YouTube at my ESQ Legal, capital letter MYESQ in capital letter, then legal. So please, when you watch, kindly subscribe. Thank you. So the topic for today is on litigation with electronic information in civil cases.
Documents, smartwatches, name it. Any device within your contemplation, you can find electronic information on it. Now, we go on to the issues of preservation of electronic evidence. What is the importance of preserving electronic evidence? As the use of electronic evidence and devices and equipment become ubiquitous in commercial dealings, it is increasingly important to ensure that critical electronic information is not lost or deleted, particularly where it's anticipated that such information will be relevant in a civil dispute. And I'm sure we all know how electronic information rules the world now, rules our everyday life. So, and it's very, very critical that once you contemplate as a dispute will arise, then you must take absolute care. In the US, there's already established protocols for on duty to preserve electronic evidence. In the US, there's what you call the legal hold process, developed in the US case of Zubulake versus UBS Warburg, where it was held that once a party reasonably anticipates litigation, it must suspend its routine document retention, destruction policy, and put in place a litigation hold to ensure the preservation of relevant documents. Now, the litigation hold obligation is triggered upon the receipt of a demand letter, formal complaint, or the occurrence of an event that typically results in litigation. I'm sure in Nigeria, most of us know who litigate, know that there are pre-litigation and pre-trial processes which require you to issue letters of demand or request to a potential litigant asking. So typically that should trigger a legal hold process if these rules were applicable in Nigeria. In the UK, counsel are under express obligation to inform their clients of the need to preserve disclosable documents, including electronic documents which may otherwise be deleted in line with the document retention policy, or in the case of business. And you can see the equivalent of the civil procedure rules there in the UK. And there's also a very interesting case, Earls versus Barclays Bank, where an inadvertent failure to preserve documents after it was clear that litigation was contemplated was held to attract adverse consequences to the litigant and a reduction in the damages eventually awarded by the court. I commend that authority. We should take some time out to read it. In Nigeria, there's no specific case law and practice direction requiring the preservation of documents. Some guidelines can be found in the Evidence Act, though, which provides that adverse inferences may be drawn where unfavorable evidence is available or is being produced. See Section 167, which is almost as old as the evidence law here. And you can see also there's a case, Simon versus the state. Also, under the rules of court, through the discovery process, though rarely used by a lot of us, an opposing litigant is required to make full disclosure, truthfully on oath, regarding any documents relating to dispute, which is or has been in his possession. You can see Order 29 of the High Court of Lagos State Civil Procedure Rules. It's quite explicit on that. In the US, now we go to sanctions for failure to preserve electronic evidence. In the US, there are sanctions if you don't preserve electronic evidence, and they're wide-ranging at the court's discretion. At the minimum, an adverse inference may be drawn that the destroyed evidence was harmful in the litigant's case. US courts can also impose monetary sanctions and exclude evidence and witness testimony as a result of misconduct. In extreme cases, if a court finds clear and convincing proof that evidence has been intentionally concealed or destroyed, the case may be dismissed in the case of the plaintiff, or a defendant found summarily liable without a trial. And there's a case, interesting case, Martin versus Daimler Chrysler Corp, which we can look up and read. In the UK, the rules also have the disclosure of electronic documents, but it does not place additional obligations on clients and their advisor, but it's intended to promote collaboration between parties to litigation and to minimize the cost and burden of disclosure exercise. However, adverse inferences, just like in the US, may be drawn by the court where available evidence is not produced. And case law has shown that there may be adverse consequences where evidence is lost or destroyed, even unintentionally when litigation was contemplated. Again, let's see, we can look at the case of Earl versus Barclay Bad, which I referred to earlier. In Nigeria, under the Nigerian civil litigation system, there are no express sanctions for failure to preserve electronic evidence, but adverse inferences may be drawn where such evidence is available and relevant or not produced. Also, where a discovery exercise is initiated and the opposing litigant fails to respond, such litigant is liable to be cited for contempt and is counsel liable to committal. You see Order 29, Rule 9, and 10 of the High Court of Lagos State Civil Procedure Rules. Now, what are the risks for preserving when you're preserving attorney-client privilege in electronic discovery? We are all familiar with what attorney-client privilege is, at least for the lawyers. They're enshrined in the Evidence Act and the rules of professional conduct. But what to know, what are the risks? And this is the meat of the matter. There's an increased risk of inadvertently disclosing privileged or protected information in the course of electronic discovery, otherwise making electronic documents available to opposing counsel because of the very nature of electronic information. For example, a party may make an effort to segregate and delete privileged information from a computer drive prior to producing electronic documents to the opposing party, but the deleted files may still be present within a larger folder structure. To put it simply, if, for instance, now you want to comply with discovery and you give access to an opposing counsel of a room where there are files, where there are filing cabinets, and you have 10 filing cabinets, 5 which you want him to have access to and 5 you do not want him to have. But if you give him access to the room and somehow you fail to lock the 5 filing cabinets you do not wish him to have access to, and he has access to that information and gets privileged information, you have inadvertently given him access to that information, and there may be a problem there. The increased risk of inadvertent disclosure in electronic discovery cases is important because of its potential effect on the attorney-client privilege or work product protection. In jurisdictions which take the strict approach to waiver, an inadvertent disclosure will result in a waiver of the privilege of protection and may extend to all other privilege or protected information related to the subject matter. Nigerian law on the inadvertent waiver of privilege. Under Nigerian law, it is unlikely that the court would view an inadvertent disclosure of counsel as waiver of client privilege. Section 1921 of the Evidence Act requires the express consent of a client before privileged information can be disclosed by counsel. Rather, an act of inadvertent disclosure is likely to be viewed as negligent behavior, which may expose such counsel to liability. See Section 9 of the Legal Practitioners Act, which provides for sanctions for professional negligence. Therefore, if only to avoid the prospect of liability for negligence, it is helpful to consider what steps may be taken by Nigeria Council to avoid such risks. So steps to be taken to avoid such risks. There's what you call a clawback agreement. If you look at your typical email that you send around, there are conditions at the bottom, usually at this, which says that if it was sent to a wrong recipient, that you should return it, that you should disregard it, etc., etc. So using clawback agreements, such agreements allow parties to specifically tailor their obligations to review and separate privileged or protected material during the discovery process. For example, before discovery begins, the parties can agree on how they will search for and separate privileged or protected material from the document productions. So long as the parties abide by the agreement, they will be permitted to take back any privileged or protected material inadvertently produced. Utilizing third-party professional e-discovery companies. Though not prevalent in Nigeria, such companies can be engaged to professionally review and flag electronic documents for potential privileged information disclosures prior to making them available to other parties. Of course, the most important one is establishing an in-house review process. The most effective step would be to develop a review process within your firm to critically examine electronic documents individually because they are sent to the before they are sent to the opposing counsel. Though this may seem like the most obvious step, it is often overlooked by lawyers or not performed with adequate diligence because of the often shared size of the information to be reviewed. Of course, we know that digital documents can be huge. And of course, in order to confuse and obfuscate the process, opposing counsel may dump a huge amount of that and the time and effort that will involve. Under Nigerian law, so we now go into the issue of electronic evidence and admissibility. Under Nigerian law, the foundation for the admissibility of electronic evidence is based on the established principles for the admissibility of paper evidence, which are relevance, materiality, and authenticity. Compared to physical evidence, the intangible quality of electronic information and the relative ease through which it can be manipulated presents a greater challenge in the verification of its integrity and its evidential value. Other jurisdictions have developed processes for verifying the authenticity of electronic evidence, such as preparing chain of custody, records, digital analysis of the attributes of electronic data, and examination of electronic fingerprint of digital files to ensure that the electronic documents have been altered. Sometime a few years ago, I wrote an article on forensic admissibility of audio and video evidence. It's quite descriptive on these issues, and I've put it in the resource slide for those that want to read further. In Nigeria, Section 84 of the Evidence Act provides a process through which court satisfies itself as to the authenticity of computer-generated evidence for the purpose of admissibility. Particularly, Section 84 requires the preparation of a certificate containing a chain of custody narrative of sort in respect of the evidence sought to be tendered into evidence. The Apex Court has also approved an additional method of proof through oral evidence under Section 84 and 84.1 and 2. Of course, the locus classicus cases of Dixon versus Silva, Cooper versus Dixon, Mishra versus Aribeshala are all very helpful. Section 93 also provides for the circumstances under which an electronic signature will be considered acceptable in court. I can talk more about this, but of course time does not permit, but the jurisprudence on this issue is quite robust, and I'm sure we can read up on that. In conclusion, it is clear that electronic evidence has come to stay, and any lawyer who wishes to function effectively in civil trials must have a clear understanding of how technology operates in relation to creation and preservation of electronic information. Technology is very dynamic and constantly changing. So our body of laws that deals with these issues of electronic information and evidence must also be changing with the evolutions that are taking place. There's no doubt that there's still room for improvement in our Nigerian rules governing electronic information. There's a law that is pending in Abuja, Electronic Transactions Bill, which deals with issues of substantive law, but a quick passage of that law will greatly help to deepen the body of law on electronic information and admissibility. Finally, I have taken liberty to compile some further resources for those that wish to read further on this, and that is displayed on the slides I'm going through. There's also, for those that want to go dig deep, there's also a very interesting course provided